the suspended Chief Justice there. And this, you can find more details of it on 3news.com. Coming up next, the Office of the Special Prosecutor is pursuing suspects in the infamous SML GRA scandal, making significant arrests as investigations continue. We've got updates and details for you here on Ghana Tonight. And these individuals, and right after this quick break, we'll get into a conversation with Edem Senano. But these individuals, also a special prosecutor, arrested Reverend Dr. Amishadai Owusu Amoa, former GRA, that is. And then also we have here, from what we got to know, the former commissioner of the Ghana Revenue Authority, this man, and he was arrested yesterday together with this gentleman as well, Christian Tetesoti, the last man, and the former technical director and advisor, and now MD of the SML. Now, these three gentlemen, we understand, spent the night, last night, in the coolest of the OSP. But there was a development today. They're not the only ones who have been arrested as we speak, and some granted bail. There are 5 other individuals who were arrested earlier today by the special prosecutor. Ivan Seduse, who is the CEO of SML, Philip Mensah, former Deputy Commissioner, Legal of the Ghana Revenue Authority, and guess what? He's also now legal consultant to SML. Kofi Nti, former Commissioner General of the Ghana Revenue Authority, and Joseph Kuruk, Public Procurement Authority official, together with Faustina Ajoko as well, who works with the Public Procurement Authority. We set the basis for this conversation on this GRA SML deal. You recall this KPMG report. The full complement of it is not out in the public domain as yet, but this is what they put out last year. And first off, that this entire SML deal, one, did not have any needs assessment done before it was awarded. And then also, there was, based on the details of the KPMG report, there was no approval by the Public Procurement Authority. And then also, the GRA board itself did not even consider and approve this SML deal before it was executed. And then, in terms of revenue to the state, the KPMG report found out that no deduction of VAT by GRA for an 8-month period on the payments made to SML, which led to some 13.838 million cedis lost to the state. Apart from that, they talk about all of these laws that they believe that the portions of this GRA SML deal has violated. The 1992 Constitution, Ghana Revenue Authority Act, Public Financial Management, Public Procurement Act, National Petroleum Authority Act, National Petroleum Authority Regulations 2012, Value Added Tax Act 2013, Public Financial Management on Revenue Regulations, Petroleum Commission Act, Minerals Commission Act, Precious Minerals Marketing Company Act, Ghana Standard Authority Act. All of these laws, according to the KPMG report, the GRA SML deal has violated a number of portions of these laws as captured in there. 8 people have been arrested, some granted bail by the special prosecutor, and these 8 people include former former commissioner generals of the GRA and 1 former deputy commissioner of the GRA, who is also acting as one of the top officials of SML as we speak. Mensano is a co-chair of the Citizens Movement Against Corruption. Edem Senano is joining us on Zoom. Thank you for joining us. First of all, I want to find out from you what you make of this development with the arrest of these persons by the special prosecutor.
Well, evidently the OSP would not be picking up these persons on the back of having done those searches a week or so ago if they didn't have very good reason to believe that they have some substantive information or they are persons embroiled in this matter, and so they needed to be, picked up. I am, in my mind, it's still part of the investigative phase, and it's good to know that these issues are not just being dropped or swept under the carpet. It's just sometimes I don't know, distressing when persons of a certain caliber appear to be involved in these things, and you are hopeful that perhaps it is not the case that they are substantively involved in, engaging in acts that are corrupt and otherwise. So we'll see how this turns out. But clearly, the most important thing is that the OSP is continuing to do the investigations, and hopefully at some point will report back to the good people of this country on their findings.
And if you look at the evolution of this SML deal, GRA extended this contract with the SML, and SML then transitioned from being a co-contractor to become the main contractor of GRA. And this was without public procurement approval, without parliamentary approval, without the GRA board's approval. And there was no deduction of VAT, so the state lost revenue. With all of these violations, what does it point to clearly in terms of the persons who could have allegedly collaborated and corroborated this entire process?
Well, yes, there appears to be conflict of interest written all over this. So the whole ethics of, on one hand, having contracts that hadn't gone through due process, requests had been made, PPA refused, they hadn't gotten the parliamentary approvals, and yet they went ahead. Meanwhile, they had all the professional skills, you have the procurement experts, you had the legal people. How could all of this happen? And then you have the transition of persons who were themselves members of GRA at one point, then transitioning to become key members in the service provider to GRA. It's just, unbelievable. So, yeah, clearly the conflict of interests is branded all over this, and why persons of such high standing would not identify this and ensure that they did not get themselves into such a situation. Mind you, the position of our constitution and most places is that you should not even put yourself into a state of position of potential conflict of interest. Public officers are supposed to be mindful not to get themselves into a situation of likely conflict of interest. So we are not even saying conflict of interest itself. The potential of it, you're supposed to be aware enough to avoid it. And so, yes, there's a lot of questions to be answered from the perspective of public officers who ought to have known better.
I thank you. Thank you very much, Adam Sedano, the co-chair of the Citizens Movement Against Corruption. Thank you for your thoughts on this. And before we go, Martin Kpebo is a private legal practitioner, and he's been following this case quite closely. He's joining us on Zoom right now. Counsel, good evening. Thank you for joining us here on Ghana Tonight.
Yeah, good evening, Mr. Kesi.
Now, listening to the detail as broken down by Dennis, and I know you followed the press conference as well earlier today, has her leadership, the Chief Justice, done herself and her case any good by addressing the press today, or Ghanaians, the nation today, and putting out this detail, which she says, in her view, it's necessary that the public gets to know how flawed, illegal, and unconstitutional the process she's being subjected to is. Has it done it good for her?
Mr. Okansi, that's $1 million question. To be honest, it's a mixed bag. You can imagine that for her supporters, certainly this would ginger them up, right? And for those who may not support the case, this will not endear her to them. So it's a mixed bag. The jury is still out there, right? Yes, but what we can be certain about is that she's come out with a lot more details than the Supreme Court has given, allows. Because the Supreme Court, through its various decisions, has made clear that we should not leak the contents of the petitions, one. We should not bring out or leak or disclose the happenings in terms of the proceedings whilst they are ongoing, etc. But you see that in the interview, she's brought out a lot, far beyond what the Supreme Court has sanctioned. That much we are very sure of. But as to how good it has done to her case, the jury is still out there.
And that particular reference you make about the Supreme Court position on going into the merits of this case, she did it today. In fact, referencing all three details of the petitions and read her responses to them as well, publicly. Would you say that in doing so, she potentially has gotten herself into some contemptuous act, an act of contempt?
Absolutely. She's bordering in that area, okay? Yes, what she's done is bordering in that area, and the word I'm using is bordering because, or as you have used the other word, potentially, because, you know, a person is innocent until proven guilty, right? And we use that principle in contempt cases, even though contempt is not a criminal matter. Some contempts are criminal. Those ones, they are in the Act 29, right? But other contempts who are civil. But whether it is a criminal contempt or civil contempt, we still use the same criminal standard that you have to prove beyond reasonable doubt. We don't have that. We don't have enough evidence. But at least what we are saying is that on the face of it, she's given a lot more details than the Supreme Court has sanctioned. So in the Justice Derry case, and it's good, this afternoon, an earlier interview with you, you would make a good lawyer someday. You know, you raised the matter of contempt. I didn't quite get it, but let's just say, put succinctly this way. Yes, we are talking about contempt, but it is not the committee that has the powers of contempt. No, the committee doesn't have. So if the committee feels these are contemptuous, then the committee has to refer the matter to the High Court. That's the difference. So when we mention contempt, then quickly we have to add that the committee has no powers of contempt. And so if there's any section in the Justice Paul Derry versus Tiger IPI case, the Supreme Court held that such matters be referred to the High Court, then the High Court will deal with the contempt application. It's not only the committee that has to refer its cases to the High Court. Also in our laws, when you are going for arbitration, when you go to arbitration and then you do something that border on contempt under the...
Unfortunate. Sorry. Lawyer Martin Pebo, we lost him there. We'll try to get him back on Zoom. He was making a point there we'll seek a conclusion to. But we also have Kwekwasa Sari, a former director of the Ghana School of Law, joining us on the telephone. Appreciate your time, sir. And I'll backtrack to that first question that I posed to Lawyer Martin Pebo as well. Hearing the her leadership Chief Justice earlier today, an unprecedented move, addressing the nation on an ongoing process, which she says, in her view, the public must know how flawed and unconstitutional, illegal this process is, and in her view is skewed towards her disadvantage, and so people must know what's going on. Has it done any good for her?
I mean, it is an established intent.
Sir.
No, the wrong approach. I don't think that this is the first time, that we are witnessing in a purported removal of a Chief Justice. This thing started, way back in 1950 or so, soon after independence and then, the Republic. And, we have the lives of Akroma and Sarko Diado. And therefore, I mean, to say that he's, sounding a caveat or warning, that, Ghanaians must share in this, it's too late, in the day. I think that I share, frustrations with her. But, the path he has chosen is not the right one. The approach is totally wrong. The committee probing the allegations was established by the president. If she has any misgivings, she must address her concerns to the president. Now that the committee is working, she cannot appear in the court of public opinion today and then next day find herself before, the committee established to go into, the allegations of impropriety against her. I think the two, cannot coexist. And being the head of the arm that watches over the justice delivery system, she must be the last person to express disfavor with the judicial process, to express a loss of confidence in the judicial process, to express frustrations, about the justice delivery system. It is, politically wrong, judicially wrong, legislatively wrong, and the fourth estate wrong. He's gotten it all wrong.
And it's interesting to check this position as well, and talking about this decision by her being constitutionally wrong and legally wrong in your view, and in the fourth estate as well wrong. And Dennis is still with me. That's